Pendalaman Sivil 23 NCBC 19/4/2014 Ko Yupo terhadap Wong Kuiman.
Dengan izin Encik Tan bagi pihak peguam plaintiff.
Oh, we are plaintiff, Pak.
Sorry, what's the question?
Plaintiff. Jared, at the outset, Jared, allow me to apologize profusely because I received an email to mention on their behalf. They are told I was supposed to be in chambers.
So it's okay, no problem.
Thank you.
Hello.
Tan bagi pihak peguam plaintiff dan pihak lawan bagi pihak peguam defendant. Hari ini untuk putusan.
I read my judgment. The plaintiff was a former secretary of the Perbadan Pengurusan Prisma Perdana Management Corporation, hereinafter referred to as the MC or PPMC, made up of 3 blocks of Prisma Perdana condominium consisting of 624 condominium units. The plaintiff's suit against the defendant is for tort of defamation over the secretary's report dated 6 November 2013, herein referred to as the impugned secretary report, which was published in the annual report of the 5th MC Annual General Meeting to all the proprietors and all residents of the unit in Prisma Perdana Condominium or their proxies who were present at the 5th Annual General Meeting AGM held on the 14th December 2013 and the deferred AGM held on the 21st December 2013. Plaintiff's claim. The plaintiff claimed that the impugned secretary report was falsely and maliciously published contained remarks concerning the plaintiff or his office as the secretary of PPMC and of his character, which are serious and constitute a grave libel of the plaintiff's reputation. The remarks in the impugned secretary report at pages 63 to 70 of the common bundle of document B1, which the plaintiff alleged to have caused severe damage to the plaintiff's image, reputation, and being hurt in his feelings, are written and published are as follows. The Secretary Kok Yupo did not call for any meeting despite the fact that the council was to meet once a month pursuant to the Strata Title Act guideline, see page 63 bundle B1 para 7, hereinafter referred to as the first impugned remarks. However, the irresponsible Secretary, Mr. Kok Yupo, did not offer any assistance to prepare the minutes of the said meeting, although this was his duty to do so. And despite his earlier claim that he was capable to carry out his duties as required of a secretary, see page 63 bundle B1 para 3 line 2, hereinafter referred to as the second impugned remarks. The response from the angry proprietors was overwhelming as they had realized that they had elected a few irresponsible persons to be council members in the 4th AGM held on 11 November 2012. Those unethical council members did not perform their duties sincerely as expected of them, but instead created a lot of problems to the extent that all PPMC employees could not receive their salaries for the 3 months. Service providers were also furious as payment were delayed for services already rendered to PPMC, see page 63 bundle B1 para 2, hereinafter referred to as the third impugned remarks. During the said meeting, Kok Yupo volunteered to be the secretary as he claimed that he was capable of carrying out his duties as required of a secretary. Thus, the council members agreed to accept his proposal, see page 63 bundle B1 at para 5 line 2, hereinafter referred to as the fourth impugned remarks. The first, second, third, and fourth impugned remarks hereinafter collective referred to as the fourth impugned remarks. The plaintiff therefore contend that he has been defamed and hence praised for in his statement of claim inter alia general aggravated and exemplary damages and an injunction restoring the publication of further defamatory words of the plaintiff in bundles A at pages 14 to 15. The defendants defend. The defendant denies that the impugned secretary report and the word complaint of contained therein refer to the plaintiff, and there was not a single word of statement to be considered as defaming or capable or defaming the plaintiff. In the event the defendant required to defend the suit and in the above premise, and contrary to claim by the plaintiff, the defendant's available defense are qualified privilege, justification, and fair comments. The law of defamation. In defamation action, the plaintiff must prove 3 elements in order to establish his case as held in Ayub bin Saud vs. T.S. Sambatamurti. A. Publication of a statement by the defendant. B. The statement refers to the plaintiff. And C. The statement conveys defamatory meaning. C. Also Kian Lab Construction vs. Hong Kong Bank Malaysia Sultan Berhad. And Subramaniam anak lelaki para Masibum vs. Court Memos Berhad and another. The law further states that the burden of proof at this initial first stage would be on the plaintiff, and if and only if the plaintiff successfully discharge his burden by proving all the 3 elements, will the burden then shift to the defendant to prove the pleaded defense. This is what is known as the second stage. See Lim Gon Eng vs. Usaha Malaysia, Berhad, as well as in Subramaniam versus Anak Lelaki Paramasivam versus Court Members Berhad and another. Publication to the third party. In order to constitute publication, the matter must be published to at least one person other than the plaintiff. Please see Gatley on Libel and Slender, 10 edition, para 6.1, and S. Pakianadan versus Jenny Ibrahim. As a secretary report, as its name suggests, contain all information on matters discussed in the meeting. Normally, the report is prepared by secretary and will be used or referred to in a future meeting. I have no doubt that the evidence before me shows that the impugned secretary report dated 6 November 2013 was prepared and published in the annual report on the 5th annual general meeting to all the proprietors and all residents of the unit in Prisma Perdana Condominium and all their proxies who were present at the 5th general meeting AGM held on 14 December 2013 and at the deferred AGM held on the 21st December 2013. It is also in evidence that the defendant himself had admitted the publication of the four impugned remarks to all the honest residents of the 624 units of the Prisma Perdana Condominium, which the defendant says in paragraph 3A of his defense in reply to paragraph 3 of the statement of claim. The defendant pleaded admitted verbatim that the defendant vigorously denies that he had acted falsely, maliciously or dishonestly in publishing the annual report of PMC, the report, following the annual general meeting of the PMC to the honest proprietors resident of all the units in Prima Perdana Condominium, Ceras, Kuala Lumpur. The defendant's admission can also be seen at paragraph 9, 10 and 11 of the defendant's updated statement of defense. The defendant further made similar admission during the cross-examination by the counsel for the plaintiff, see page 46, line 5, notes of evidence on 16 October 2014. Hence, it cannot be denied that the defendant had widely published the impugned sector report to 624 units of the Prisma Perdana Condominium. Thus, I agree with the plaintiff counsel that many people had read the false impugned remarks. Referring to the plaintiff must prove that the impugned remark referred to him and was published of and concerning him. The plaintiff counsel has referred to the case of House Lot in the leading case of Naffa versus London Express Newspaper Limited, which stress confirmed this strike principle when their lordship interior opined it is an essential element of the cause of action for defamation that the words complained of should be published and of concerning the plaintiff. The defendant submitted that the impugned secretary report and the words complained of contained therein did not refer to the plaintiff, and further submitted that there were 7 or 8 members in the MC. At the matter of time, it would be impossible for the plaintiff to establish that he was in fact included in the defensive statement. Furthermore, the plaintiff has not proved in court that he was the person who could be included in the group. Without establishing that he was included in the group, the reasonable person of average intelligence would not regard as part of the group. Therefore, the plaintiff could not maintain the defamation suit. However, my analysis of the pleading and the evidence before me, it shows that the first, second, and fourth impugned remark were published of and concerning the plaintiff, in that the impugned remark expressly referred to and identified the plaintiff to in the 3 instances. And during cross-examination, the defendant had admitted that the first, second, and fourth impugned remark referred to the plaintiff, see page 48, notes of evidence on 16 October 2014. The third impugned remark, which referred to the council members who were elected in the 4th AGM held on 11 November 2012, again were clearly published of and concerning the plaintiff, in that minutes of the 4th AGM should confirm that the plaintiff was elected as a council member on the 4th AGM, see page 35, bundle B1. Further, under cross-examination, the defendant admitted that the plaintiff was one of the people referred to in the third impugned remark, see page 50 and 51, notes of evidence on 16 October 2014. Analyzing the impugned secretary report, especially the whole paragraph 5 and 7 on the impugned secretary report, and under the same heading, namely 28 February 2013, see page 3, bottom bundle B1, right up to the paragraph 3 of the next page, the name of the plaintiff, Ko Yupo, was repeatedly mentioned and centered around the problem and unprecedented crisis faced by the MC and culminating to the so-called dialogue meeting, see page 4, Parawan bundle B1 on 28 February 2013, would inevitably giving the impression that to any ordinary reader that the attack were all pointed at Ko Yupo. In this regard, the learned judge in the case of on point of WLP Industrial Solution, Sdn Berhad versus KL Kepong Rubber Products Sdn Berhad, has aptly reasoned out paragraph 18 at page 632E that, to my mind, it is not necessary that the plaintiff be referred to in each and every paragraph which contain an alleged defamatory statement in order for person reading page P37 to make the reasonable inference that throughout the letter, the adverse comparison was attributed to the plaintiff. Hence, from the evidence, the plaintiff has established that all the 4 impugned remarks were indeed referred to the plaintiff. Were the words complained of defamatory? The plaintiff has proved the above two elements, and it is now for the plaintiff to prove the impugned remarks or words complained of in the impugned secretary report in their natural and ordinary meaning and or by way or inference were defamatory of him. The plaintiff submitted that by the first impugned remark, which expressly accused the plaintiff did not call for any meeting, despite the fact that the council was to meet once a month pursuant under the Strata Title Act guidelines, the STA guideline, it would convey to an ordinary reasonable person the negative impression that the plaintiff had breached the duty imposed upon him under the STA guideline, and that he was an irresponsible person. Hence, the first impugned remark tend to lower the plaintiff in the estimation of others, especially the resident of the 624 units of the Prisma Perdana condominium. By the second impugned remark, which expressly accused the plaintiff as an irresponsible secretary who did not offer any assistance to prepare the minutes, although it was his duty to do so, and despite the plaintiff had earlier claimed that he was capable to carry out the duties as required of the secretary, would convey to any ordinary reasonable person the negative impression that the plaintiff was an irresponsible secretary, and that the plaintiff did not keep to his promise, in that he was not a man of his word. As such, the second impugned remark tend to lower the plaintiff in the estimation of the others, especially the resident of the 324 unit of the Prisma Perdana condominium. By the third impugned remark, which painted the picture that angry proprietors had realized that they had elected a few irresponsible and unethical council members who did not perform their duties sincerely, instead has caused lots of problems to the extent that staff did not receive their salaries for months and fuel service providers were delayed in their payment, would convey to any ordinary reasonable person, especially proprietors and residents of the Prisma Perdana condominium, the negative impression that the plaintiff was an irresponsible and unethical council member, and did not perform his duty sincerely, instead has caused lots of problems. Hence, the third impugned remark also tend to lower the plaintiff in the estimation of others, in particular the resident of the 624 unit of the Prisma Perdana condominium. By the fourth impugned remark, which expressly accused the plaintiff had purportedly volunteered to be the secretary by claiming that he was capable of carrying out his duties as required of a secretary, and of his own proportion only then he was accepted as the secretary of the MC, which, especially reading as a whole with the first, second, and the third impugned remark, would convey to any ordinary reasonable person the negative impression that the plaintiff was an irresponsible secretary who did not keep to his promise, and that he was not a man of his word and a liar. Hence, the fourth impugned remark also tend to lower the plaintiff in the estimation of others, especially the resident of 624 units of the Prisma Perdana condominium. It is the plaintiff's case that an ordinary and reasonable man who reads the fourth impugned remark in the impugned secretary report as a whole, the impugned remark conveyed the natural and ordinary meaning that the plaintiff was an unethical person and he was an irresponsible secretary who had breached his duties and did not keep his promise, besides did not carry out his duties required of him, such as preparing the minutes of the said meeting. On the other hand, the defendant submitted that the first statement is true in fact and in substance, therefore defense justification applies. As for the second statement, the statement is defective as the pleading did not identify which word or sentence which alleged to be defamatory. Therefore, breach of Order 78 Rule 3 Rules of Court 2012, be that as it may, the word in response victory and did not offer assistance to prepare minutes of the said meeting are not defamatory, as they are essentially true and accurate in fact and in substance. Therefore, justification is a complete defense to the second statement. As to the fourth statement, the defendant says it is a non-starter. Such statement cannot be regarded as lowering the estimation of the plaintiff among right-thinking people of society, or cause plaintiff to be shunned, or the plaintiff is subject to hatred, contempt, or ridicule. Therefore, there can be no defamation at all in respect of the fourth statement. It was submitted that in any event, word irresponsible secretary appeared to be strong word, but it cannot be deemed to be capable of defaming the plaintiff as used in its context and the circumstance of the publication. The dictionary definition of responsible means that someone who does something not caring about the consequences of his action. Similarly, the defendant submitted that such word irresponsible secretary did not impute bad character on the plaintiff, did not attack on the character or reputation or integrity of the plaintiff, and furthermore, considering the fact that it was true that the plaintiff did not prepare and assist to prepare the minutes of the dialogue meeting, the word is merely describe a person's attitude or conduct in his or her work. Someone who do not bother about the consequences of his action. Therefore, accordingly, the word irresponsible secretary is not capable of defaming and did not defame the plaintiff. Such admission provides complete defense to the second statement. It was further submitted by applying the objective test. The statement cannot by any stretch of the imagination could be regarded as a disparaging the plaintiff. Such statement would not cause readers or reasonable person or average intelligence to think lower in estimation of the plaintiff the plaintiff would not be shunned or avoided by the general public or subject to hatred or contempt or ridicule. The defendant further submitted that there are insufficient particulars or facts stated in the pleading or in the false statement to support or justify the plaintiff claim that the false statement was capable of defaming the plaintiff. In summary, the plaintiff's false statements are not capable of defaming the plaintiff and did not defame the plaintiff at all. As for this court, in determining whether words are defamatory, there are two stages. First, to decide what they mean, and then to decide whether that meaning is defamatory. See Gatley on libel and slander, para 2.1 at page 28, second para, where Gatley further opine, a defamatory imputation is one to the claimant's discredit, of which tend to lower him in the estimation of others, or causes him to be shunned or avoided, or exposes him to hatred, contempt, or ridicule. The principle on the test whether the word could amount to defamatory or not are found in many decided cases. The test is would the word tend to lower the plaintiff in the estimation of the right-thinking member of society generally. The renowned case of Yusupov versus Metro Golden Mayer held that an imputation may be defamatory even though it does not tend to make others think worse of the person to whom it refers, nor expose him to ridicule if it would tend to cause others to shun or avoid him or to exclude him from the society of his fellow men. In Tun Datuk Petinggi Haji Abdul Rahman Yaakob versus Bri Sdn Bhd, Richard Olanjun says the test whether the word complained of in the article were capable of being and were in fact defamatory of the plaintiff was whether such words were calculated to expose him to hatred, ridicule, or contempt in the mind of reasonable men, or would tend to lower him in the estimation of the right-thinking members of society generally. The approach in the construction of the word complained of is to consider the meaning such word would convey to an reasonable person using their general knowledge and common sense. No necessity for the plaintiff to prove falsity of the words complained of once they were found to be defamatory of him. See also renowned case of Rahman Talib versus Sinava Sagam and another. In Janting Handicraft Sdn Bhd versus Utama Malaysia, the learned judge, in agreeing with and accepting the test by Azmi J, as his lordship then was, inside Hussein Ali versus Syarikat Percetakan Usaha Melayu Sdn Bhd, wherein his lordship said at page 58 as follows. Thus, the test of the defamatory nature of the statement is it tendency to excite against the plaintiff the adverse opinion of others, although no one believes the statement to be true. His lordship further refers to a passage by Octian J in the Straits Times Press Limited versus Workers' Party and another. The natural and ordinary meaning is that which would reasonably understood by ordinary person using their general knowledge and common sense, and this includes any inference which can be reasonably drawn from the words. In this instant case, the subject matter of the defamation suit, libel against the defendant, is the impugned remark contained in the impugned secretary report. In this respect, I agree with the defendant counsel that when considering word complaint of a defamatory of the plaintiff, the whole article must be read in totality and not in isolation. The entrance principle in libel is that the reader of a defamatory article read its whole content and form the opinion. In Charleston versus New Group Newspaper Limited, Lord Bridge observed that the ordinary reader is treated as having read the publication as a whole in determining the meaning. See also Hospital Law of England, refers to Slim versus Daily Telegraph and Datuk Sri Anwar Ibrahim versus New Straits Times Sdn Bhd. It has also been decided that words in themselves apparently innocent may be shown to have a defamatory meaning when they are read with reference to the circumstances in which they were written and with reference to the context in which they appear. Words which are not in themselves defamatory may, from the whole context in which they are published, convey a defamatory imputation. See Gatley on libel and slander, 10th edition, at para 3.28 and Robert versus Patilo. The plaintiff submitted that the first, second, third and fourth impure remark reading as a whole, and in this regard, the fourth impure remark reading together with the first, second, third and third impure remark as a whole, convey the meaning that the word complained of were indeed defamatory. In addition, it was further submitted that it is the nature of the allegation, not the effect, which is important for this purpose. Gatley on libel and slander, para 2.1, page 29, second para, further opine, to be defamatory, an imputation need have no actual effect on a person's reputation. The law looks only to its tendency, so there is a cause of action even if the words were not believed by the audience. In Hawke versus London Express, Goddard LJ says that if the words are used which impute discreditable conduct to my friend, he has been defamed to me, although I do not believe the imputation and may even know is untrue. See also Morris Morgan and versus Alden Press Limited. Lord Reed in House of Lords, Lewis versus Daily Telegraph, further opine what ordinary man would infer without special knowledge has generally been called the natural and ordinary meaning of the words. Sometimes it is not necessary to go beyond the word themselves, as where the plaintiff has been called a thief or a murderer. This court agrees what was said in the leading case of Capital and Counties Bank Limited versus Henty and Sons, where Lord Selborne LC says the test, according to the authorities, is whether under the circumstances in which the writing and published reasonable man to whom the publication was made would be likely to understand in its liberal sense. At the same time, the abstraction of the reasonable man was to create a balance between freedom of speech and the protection of reputation. The test of whether the words are capable of conveying a definite meaning is a question of law calling for audition by the court. See Wong versus Azmi M. Anshar and Ayub bin Saud versus T.S. Sambandramurti. The Singapore Court of Appeal in Microsoft Corporation versus SM Summit Holding Limited held that the principal application in determining the natural and the meaning of the word complaint of in litigation action are well established. The court decide what the meaning the word would have conveyed to an ordinary reasonable person using his general knowledge and common sense. Jeranam Joshua Benjamin versus Goh Chok Tong and Jeranam Joshua Benjamin versus Lee Kuan Yew. The test is an objective one. It is the natural and ordinary meaning as understood by an ordinary reasonable person, not unduly suspicious of avid for scandal. The meaning intended by the maker of the statement is irrelevant. Similarly, the sense in which the word was actually understood by the party alleged to have been defamed is also irrelevant. Nor is extrinsic evidence admissible in construing the words. The meaning must be gathered from the word themselves and in the context of the entire passage in which they are set out. The court is not confined to the literal or strict meaning of the word, but takes into account what the ordinary reasonable person may reasonably infer from the words. Whether the word complained of in the false impugned remarks in the impugned secretarial report in any way convey the defamatory meaning which the plaintiff claimed it conveys as set out in statement of claim, or any other meaning defamatory of him, or are there other passages or words in the impugned secretarial report that take away the sting? So Chun Seng versus Sitos EMR Sidang Berat. The defendant submitted that at page 54 of impugned secretarial report at paragraph 5 under March 2013, the defendant stated no further council meeting was called by the secretary as EGM would be convened on the 17th March 2013. Such statement by the defendant in fact did not blame the plaintiff for not calling monthly meeting on March 2013, therefore removed sting from allegation that the plaintiff had irresponsibly failed to call council meeting when he was secretary. Analyzing the impugned secretary report at paragraph 5 under March 2013, as submitted by the defendant, in my opinion, the statement does not expressly exonerate the defendant or the said word or statement is capable of taking away the sting, because the impugned remarks are not confined to the failure to call council meeting alone, but also include the charges of being irresponsibly failed to prepare the minutes of the meeting and other problems facing the employee salaries and payment for services providers of the PPMC. In the instant case before this court, and by applying the objective test, I am satisfied that the impugned remark or words complained of in the impugned secretary report are distinctly, clearly defamatory and not necessary to go beyond the word themselves. To accuse someone unethical or responsible, as in the third and fourth impugned remark, clearly and squarely fit into the ambit of Lord Reid dicta in Lewis versus Daily Telegraph Supra. It is undoubtedly obvious that the image and reputation of a person, in this instance, the plaintiff who was accused of being unethical and responsible, would definitely be lowered in the estimation of the right-thinking members of the society, especially his neighbours, folk in Prisma Perdana Condominium, and he will be hated and despised. See Pamita versus Copeland, Sim versus Trash, and this would tend to cause others to shun or avoid him. See Yosefo versus Metro Golden Mayer. In fact, to say someone is not quite responsible for what he does is held to be defamatory. See Pierce versus Symes. For an allegation to be considered defamatory, it must impute to the claimant either some quality which would be detrimental to the successful carrying on his office, profession, or the absence of some quality which is essential to his success. See David Price in Defamation Law, Procedure and Practice, para 2.21 at page 20, 3rd edition, and also Gatley on Libel and Slander, 10th edition, para 2.6, and at page 59. In the instant case, it is not disputed that the plaintiff was an officer of the PMMC or MC. He was elected council member on 11 November 2012. A month later, on 13 December 2012, he was endorsed as the secretary and ceased to hold post on 24 March 2013. The false impugned remark had imputed to the plaintiff some quality which would be detrimental to the successful carrying out his office as the secretary of the MC, or absence of some quality was essential to his success. To it, the plaintiff did not call for any meeting despite the purported fact that the council was to meet once a month pursuant to the ST Guideline, the first impugned remark. The irresponsible secretary, Kok Yupo plaintiff, did not offer any assistance to prepare the minutes of the said meeting, although it was his duty to do so, and despite his earlier claim that he was capable to carry out the duties required by secretary, the second impure remark. The proprietors realized that they had elected a few irresponsible and unethical persons, including the plaintiff, to be the council members in the fourth AGM, did not perform duties sincerely as expected, but instead created a lot of problems, the third impure remark. Kok Yupo had volunteered to be the secretary as he claimed that he was capable of carrying out the duties as required by secretary, the fourth impure remark. View objectively, an ordinary and reasonable man who read the fourth impure remark in the impure secretary report as a whole, the impure remark conveyed the natural and ordinary meaning that the plaintiff was an unethical person and he was an irresponsible secretary who had breached his duties and did not keep his promise, besides did not carry out his duty required of him, such as preparing the minutes of the said meeting. He even refused to offer any assistance in that regard. In Louis vs. Daily Telegraph, Supra, their lordship further stated earlier that the ordinary reader take notice of the circumstances and the manner of the publication, such as the prominence given to the allegation. Where a particular matter is given in the newspaper, it will be assumed that it is one of the significant and is therefore more likely to convey a defamatory meaning to the ordinary reader. In the circumstances, it is my opinion that the impure secretary report, which was published by the defendant, contained remarks concerning the plaintiff and or his office as secretary of MC or PMC and of his character, which constitute a libel of the plaintiff's reputation. The plaintiff has successfully discharged his burden, and the burden is shifted to the defendant to prove his pleaded defence. The defendant defends. The defendant pleads or relies on the defence of qualified privilege as his main defence, where he says that he had a duty and responsibility of interest, legal, moral and social as secretary to publish and distribute the said report to all apartment or condominium owners and corresponding interest by owners to receive the report. Alternatively, the defence of fair comment, where the plaintiff had failed to call for monthly meeting at that time, February and March 2013, and the matter was a public interest and the comment made was honestly made without malice or malafide. Alternatively, the defence of justification, where there was a failure by the plaintiff to call for a monthly meeting of PPMC, February and March 2013, and whereby the statement was published in good faith, honestly, without malice, and based on the truth of what had actually happened, and the matter involved was a public interest. Muhammad Zaidin J, as he was then in Ayub vs. South, TS-Multi, said that where a defence of qualified privilege is set up, as in this present case, the burden lies on the defendant to prove that he made the statement honestly and without any direct or improper motive. Then, if he succeeds in establishing qualified privilege, the burden is shifted to the plaintiff, in this case, to show actual or express malice, which upon proof thereof, communication made under qualified privilege could no longer be regarded as privilege. Raja Gopal vs. Raja. At paragraph 14 of the statement of defence, the defendant says that he was discharging his duty as secretary of publishing the report based on actual event taking place or based on the truth, and he had published the report with transparency, honestly and sincerity and without malice to the plaintiff. Further, it was submitted that the first statement is true in fact and in substance, therefore defence of justification applied. This, according to the defendant, can be shown during the trial that the act of publishing of the secretary report in November 2013 was to include the report which noticed 5th AGM to be held on the 14th December 2013 and to be sent out to all condominium owners. Please see page 25 and 26 of Lampiran B1. The defendant submitted that the evidence has supported his contention that the plaintiff did not call for monthly meeting of MC during his 3-month tenure as secretary. The email between Mr. Chow, chairman, and the plaintiff, as well as evidence of Mr. Chow as chairman, confirmed that the secretary report had been vetted and approved by the entire committee of the MC before it was published and sent out to owners of PPMC. The document at page 85-86 of Lampiran B1, which showed that by 15 January 2013, the plaintiff has not called for council meeting. For 27 January 2013, the chairman was still asking why the plaintiff was not calling council meeting and the treasurer should not calling council meeting. The second email showed that the chairman was unhappy with the plaintiff for not performing properly his job. At page 94 of Lampiran B1, the chairman emailed to the plaintiff that the secretary was supposed to call for a meeting in February 2013 and queried why notice had not been sent out for the meeting. At page 95, the chairman decided to call for a meeting to be held on the 20th February 2013. Therefore, the defendant, relying on the document and email, was entitled to conclude that the plaintiff did not call for council meeting for January and February 2013. In his Q&A and re-examination, the defendant was consistent that he had carried out thorough investigation and perusing the MC office record regarding the above two matters, and he was certified he has published the secretary report was true and honestly published based actual event which had occurred. Therefore, based on evidence of the defendant supported by evidence of Ms. Valerie Tung and Mr. Chow as well as Mr. Vijay, the defendant has taken proper steps to verify the matters mentioned above and the report is true and accurate. Furthermore, Mr. Chow as chairman confirmed that the secretary report had been vetted and approved by the entire committee of the MC before it was published and sent out to owners of MMC. The defendant did not produce any evidence to contradict the evidence of the defendant and his two witnesses regarding the verification and checking of fact by the defendant. Please refer to Part A of the defendant's submission, where there was no rivalry or hostility between the both of them. No evidence was presented to court by the plaintiff of any intention to harm the plaintiff by the defendant. As such, the plaintiff could not prove malice on the part of the defendant in publishing the second report. In page 32 and 45 of the plaintiff's submission, the plaintiff illogically claimed that the defendant knew that the false statements were untrue to substantiate claim of malice on the part of the defendant. Such allegation is far-fetched and totally false and misleading, tantamount to fabrication. In his evidence in chief during cross-examination and re-examination, the defendant had constantly maintained that he had carried out thorough investigation before he published the report some 9 months after he took over as secretary. The defendant has stated that he had referred and perused the MC record and file relating to the plaintiff's performance, and even at the dialogue meeting, he has checked with the chairman and Ms. Valerie Tung. Boss had confirmed to him that the plaintiff did not prepare and did not offer to help to prepare the minutes of the dialogue meeting. The defendant had also noticed page 20 of the Lampiran B3 in which the plaintiff had promised to call monthly council meeting. He has checked with the chairman and perused email messages between the chairman and plaintiff which led to the defendant to state that the plaintiff did not call any monthly meeting, which was true in substance. Based on email message, Mr. Chow had called for a meeting for February 2013. For January 2013, Mr. Chow had reprimanded the plaintiff for not calling January meeting, which he levied to Lee Kok Hao, the treasurer, to call for the meeting. In page 55, bottom part of Lampiran B, the defendant unbiasedly stated that the plaintiff did not call for March monthly meeting because of a GM to be held in March. Therefore, the defendant's case is that the plaintiff has no basis to falsely claim that the second report of four statements in the report were untrue, and the false defendant had known the statement to be untrue. Hence, the plaintiff had no basis to claim that the report was published with malice or published recklessly or dishonestly by the defendant. The reply by the plaintiff in his reply to defense did not disclose any fact or particulars to substantiate the plaintiff's frivolous claim or alleged malice by the defendant. Such allegation of malice without any proper proof must be rated by the court. Quite long. In reply, the plaintiff contended, because this is full trial. In reply, the plaintiff contended that the publication of the false impure remark were not published on an occasion of qualified privilege. The defendant is not protected because the statement was not fairly warranted by the occasion, i.e. does not fall within the scope of the purpose of which the law grant the privilege, and the statement was made with malice or improper motive or knowing it to be untrue, or with reckless indifference as to its truth. See Gatley on Libel and Slander, paragraph 14.1 and page 379, and Abdul Rahman Talib versus Sini Bersagam. The plaintiff submitted that in this case, the false impure remark were not fairly warranted by the occasion, on reason as follows. That the defendant, in writing publishing the impure second report, he had an interest and duty to publish the resident matters regarding affairs and business or prima perdana condominium for which the resident have corresponding interest to receive. That the defendant had no interest or duty to publish personal gossips and unfounded attacks in the form of false impure remark to the resident, and on the same footing, the resident had no interest to receive them. Bluntly put, personal gossip and attack were not matters of public interest. Hence, the defendant, in his purported capacity as the secretary of the MC, had no interest or duty to publish them, and the resident had no corresponding interest to receive them. The plaintiff referred to the case of Datuk Arif Muhammad Saleh versus Datuk Muhammad Syed Haji Abdal, wherein at page 389, Hamid Sultan JC opines, merely reporting matters which can prima facie be seen objectively as defamatory cannot be said to be fair if the accuracy of the report is not verified by the publishers. In this instance case, the defendant has stated that the words complained of he alleges a statement of fact, and of the fact and matters he relied on is in support of allegation that the words are true. It is tried law that the only way to defeat defences of qualified privilege and fair comment on a matter of public importance is for the plaintiff to plead and prove express malice. The onus lies on the plaintiff to prove malice and not the defendant to prove his bona fide or essence of malice. Per KS Segara J in Ho Tian Sun versus Lee T.K. What is meant by malice? Put succinctly, the common law has always regarded malice as the publishing of of publishing of defamatory material which an improper motive, Rackham versus Sandy, unreported. Paragraph 18, citing decision of the High Court of Australia in Robert versus Bass. In Horrock versus Lowell, Lord Diplock described malice in the following term. So he is entitled to be protected by the privilege unless some other dominant and proper motive or spite is proved. Express malice is the term of art descriptive of such a motive. Broadly speaking, it means malice in the popular sense of a desire to injure the person who is defamed, and it is generally the motive which the plaintiff set out to prove. But to destroy the privilege, the desire to injure must be the dominant motive for the defamatory publication. Knowledge that it will have effect is not enough if the defendant is nevertheless acting in accordance with the sense of duty or in the bona fide protection of his own legitimate interest. In short, in order to establish express malice sufficient to defeat the defense of fair comment or qualified malice, the plaintiff must establish that the defendant was actuated by or dominant desire to injure the plaintiff. It is not enough to establish that the reporter was careless or acted unreasonably unless it is also established that he was deliberately careless or unreasonable because he was actuated by a dominant desire to injure the plaintiff. Knowledge or recklessness as to the falsity of the report is not in a separate head or malice. It is only part of the evidence which the court must consider together with other evidence when deciding whether the reporter was actuated by an improper motive. Malice. Flowing from the defendant's contention, this court has analysed the plaintiff pleading, and I am certified that the particulars of malice is pleaded in paragraph 6A to F and 7 to 9 of the plaintiff's reply to the defendant's statement of defense. In the trial, the plaintiff went on to prove such facts that constitute malice were present in publishing the defendant's remark that defendant knew charges were not true, no evidence of the impure remark, and instances of other charges are also not true. After analysing the evidence adduced before this court, I fully agree with the plaintiff's submission and certified that there are instances of malice on the part of the defendant as shown as follows. Defendant knew charges were not true. The defendant who told the court in his updated statement of witness A12 and while giving evidence in court that he had conducted thorough investigation, the defendant insisted that he had made thorough investigation, see page 97, bottom note of evidence, on the performance of the plaintiff on his own volition, was supposed to know the truth. Yet he wrote and published the impure remark to the resident knowing that the allegation or charges were not true. The evidence during cross-examination by the counsel for the plaintiff produced below demonstrated the malice on the plaintiff. No evidence or impure remark. As regard the first impure remark, the first defendant accused the plaintiff did not call for any meeting, but when Gmail report at page 138 and 139 were produced in court, the defendant reluctantly admitted that the plaintiff had called for the meeting stated in the Gmail. When further questioned by the plaintiff counsel, the defendant finally agreed that the impure report, together with the whole bunch of OGM papers sent to all practice residents of the prima pradana condominium, would make the people think that the plaintiff did not call for any meeting during his tenure as the secretary of the MC. See page 92, notes evidence on 16 October 2014. The defendant also admitted under cross-examination that he had painted the plaintiff as a useless secretary and wrongfully accused the plaintiff as irresponsible and unethical. This evidence can be seen at page 94, para 1 to 5, para 11 to 13, notes evidence on 16 October 2014. Further, the defendant in supplementary Q&A said that the plaintiff did not call for a monthly council meeting on the MC in February and March 2013. However, by provision of the law and the decision of the MC itself, there was no requirement to call for monthly council meeting. As submitted by the plaintiff, Rule 3 of the Title Act 19, STA provide that the council shall meet at such time and places and at such interval as it thinks fit, provided that any member of the council may convene a meeting by appointing a date for the meeting and giving to the other members not less than 7 days notice of the date appointed. Therefore, it merely provides that any member of the council may convene a meeting, which means calling for council meeting was not confirmed to as the duty of an MC secretary under Rule 3 of the STA. Result of page 20 of B3, there was in fact a standing order resolved by the MC on 13 December 2013, which the plaintiff has stated therein about monthly council meeting was to be held on Thursday in the third week of the month and was confirmed by the plaintiff under cross-examination by the defendant counsel. See page 7, bottom notes of evidence on 15 October 2014. Therefore, the evidence itself would soundly rebut the accusation launched by the defendant in the form of the first impure remark that the defendant did not call any council meeting, and this demonstrates the defendant's malice. In the so-called thorough investigation on the performance of the plaintiff on the volition of the defendant, the evidence only shows that the defendant interviewed the chairman, the building manager, and the staff to whom, but he did not even make any attempt to interview the plaintiff, who was the target of his thorough investigation. I fully agree with the plaintiff counsel submission that the defendant published an impure secretary report to the proprietor resident painted an extremely serious picture about the painted status of the MC, that it was facing an unprecedented crisis whereby check statement of account and invoices couldn't be issued, see page 4, para 1B1, and put all the blame on the plaintiff with the publication of false impure remark which were not true in that the minute of the so-called dialogue meeting was not required at all for the MC to function as usual, in that all payments were issued as usual without any problem. The email at pages 82, 93, 97, B1 showed that the check were being issued for various payments without problem. Further, the email dated 15 March 2013, just before the EGM on the 24 March 2013, as seen in page 162, showed that the chairman Chow Ten Chow had plaintiff and Andy Lee to present check for utilities and staff salaries as preemptive measures whereby this check were to be released after the EGM. Apparently, this was to avoid delay in payment should there be any change in signatories after the election on 20 March 2013, but Chow Ten Chow had not done likewise before the fourth AGM on the 11 November 2013, see page 52 bottom, loss of evidence on 29 January 2015. I also agree that the defendant did not review or report in the impure secretary report that the chairman Chow Tian Chai had failed to arrange check for utilities and staff salaries to be pre-signed, thus resulted to the little hiccup in the issuance of the check post the fourth AGM in i.e. November and December 2012, but instead accusing the plaintiff for delay in signatories, change in bank which shall be rebutted by the document in pages 14 to 22 of B3. During the proceeding, the court was shown that the email at pages 81, 81A to 101/101A bundle B1, there were the intriguing two versions of the minutes of the so-called dialogue meeting on the 28 to 013, pages 8 to 13 and page 4 to 7 before. The minutes in page 8 to 13 was originally produced as ID1 attached to the defendant updated statement of witness, while the minute in page 4 to 7 was introduced after the trial comment. The evidence can be also seen in notes of evidence at pages 37 to 42 on 16 October 2015. This court censored something is not right there after DW1 and DW2 admitted they could not explain. The evidence led during cross-examination on the defendant witness DW1 in notes of evidence at pages 33 to 35 on 29 January 2015 would reveal that the first impure remark were not true. I agree with the plaintiff counsel that the defendant had used the occasion in publishing the impure secretary report which contained the false impure remark with indirect or improper motive. Bear in mind that the defendant took 6 months in writing the impure secretary report, claiming that he had conducted a thorough investigation on the performance of the plaintiff, which the defendant had finally admitted the performance of the plaintiff had nothing to do with him. The defendant purportedly conducted a thorough investigation on the performance of the plaintiff, reflect malice on his part on the false impure remark published by him to the all resident of 624 unit of Prisma Perdana Condominium, which proved to be not true and was absolutely far-fetched and false, demonstrated malice on the defendant. In Harry Isaac and other versus Berita Harrison Berhad, the Court of Appeal ruled that if false and defamatory words are published, malice is presumed. In Datuk Sri Utama Dr. Rais bin Yatim versus Amir Zuddin bin Ahmad, the learned judge opined that there was no effort, no attempt at all on the part of the defendant to verify the allegation before publishing. This clearly shows malice on the part of the defendant. In the instant case, the defendant did not seek verification from the plaintiff before the published the impure remark in the impure secretary report that clearly demonstrates malice of the defendant. The use of the word irresponsible and out of the blue, the word unethical on the petty, tiny issue of calling the monthly council meeting and preparation of the minute, which was not and could not be confined to the duty of the plaintiff. Furthermore, the allegation had proved to be untrue, would clearly demonstrate malice on the defendant. I agree with the plaintiff counsel that the manner and circumstances of the publication of the impure remark would further reflect malice on the part of the defendant. Late LJ held in Stewart versus Bell, that malice in fact is not confined to personal spite and ill will, but includes every wrong feeling in a man's mind. In Gilpin versus Fowler, held that there will be evidence of malice if it can be proved that the defendant was actuated by personal resentment. In the instant case, the defendant and his chairman Chow Ten Chai were fully aware that the plaintiff had lodged complaint against the MC for their improper conduct of the GM as well as their infringement of the STA, for instance page 3, 4 and pages 18 to 23 of B1. And I agree that with the plaintiff counsel submission that the fact that the defendant had firmly refused to approve payment vouchers or the defendant chairman had understandably caused resentment in mind of the defendant. Conclusion. After hearing oral and documentary evidence and after hearing oral submission from the plaintiff and defendant's counsel, And reading their written submission, file hearing on the balance of ability, the defendant had failed to prove any of the defences. I am satisfied that there was insufficient evidence to show that his charges against the plaintiff or any of the impugned remark was true or sufficiently true, and while the defendant had not established the defences of fair comment or qualified privilege, and even so would clearly be destroyed by the abundance of malice of the defendant. Therefore, the plaintiff had established his claim against the defendant. Based on the evidence before this court, I am also convinced that when the defendant published the impugned remark, he knew and he had reason to know they were false or untrue or reckless. Whether they were true or false, he was actuated with malice. As such, he is not entitled to the protection of the privileged damages. The defendant is liable for his action. The plaintiff claimed against the defendant for general aggravated exemplary damages and injunction restraining the defendant from further publishing the defendant's remark. Plaintiff must be compensated, and the next question is how much will be the quantum of damages for his loss or reputation. In Datuk Seri Utama Datuk Rais bin Yatim versus Amiruddin bin Ahmad, it was held that a particular libel case cannot be equated with other libel cases. Each libel case is unique and has its own particular and peculiar facts. In Kesatuan Kebangsaan Pekerja versus the New Straits Times, it was held that the thought of libel has been recognised as actionable per se. Thus, where a personal plaintiff proved publication of false statement damaging to his reputation without lawful justification, he need not plead or prove special damage in order to succeed. See also Chong Chak versus Government Malaysia. The plaintiff submitted the case of Harry Isaac versus another versus Berita Harian Sinar Berhad, Shukra, where the Court of Appeal awarded 75,000 by way of aggravated and exemplary damages. In Datuk Seri Anwar Ibrahim versus New Straits Times Press, the court awarded the sum of 100,000. In Datuk Haris Muhammad Salih versus Datuk Muhammad Syarbi Abdal, the court awarded the sum of 50,000. In Khalid bin Abdul Samad versus Datuk Aziz bin Isham, the court awarded the sum of 60,000. In determining quantum of damages, I have considered the following factors stated in the case of Datuk Dr. Tan Chi Kwan versus Chin Chung Seng and Datuk Seri Utama Dr. Rais bin Yatim versus Amiruddin bin Ahmad. A. The conduct of the plaintiff. B. The plaintiff's position and standing in society. C. The nature of the libel. D. Mode and extent of publication. E. The absence of refuse or retraction of apology. And F. The whole conduct of the defendant from the time the libel was published down the very moment of the verdict. Based on authority cited above, this court allowed the general and aggravated damages in a global sum of 50,000 to the plaintiff. This court disallowed the claim for exemplary damages or its finding that the circumstances in this case do not warrant such damages being awarded to the plaintiff. The principle of law can be found in Gately or Liberal Standard 11 edition. Exemplary damages are often awarded to punish the defendant for a willful commission of a tort or teach him that the tort does not pay. The award of exemplary damages is differentiated from the aggravated damages in that it is to be awarded in the following three situations. 1. Where it is recognised by the statute, where the wrong involves oppressive, arbitrary or unconstitutional action by servant or the government, where the defendant tortious act has been done with guilty knowledge for the motive that the chances of economic advantage outweigh the chances of economic or perhaps physical penalty. Please see Roshari Bisa Abdul Wahab and Major Mustafa, where James Fung has applied the principle of law in Lucas versus Barak. It is this court opinion that the amount awarded to the plaintiff is fair and reasonable following the current trend or award in defamation cases. The decision is made after taking into consideration the fact of the case and the manner of charges made against the plaintiff in the second report dated 6 November 2013. So the decision of the court, in the premises, the plaintiff claim is allowed against the defendant as follows: general and aggravated damages in a global sum of 50,000 only, an injunction restraining the defendant whether by himself, his agent or servant from further publishing the defamatory remark or other similar words in whatever manner or form, interest 4% from the date of judgment to date of payment, and cost of RM 20,000. Thank you.
Jarif, allow me to just mention, Jarif,
Yeah.
I'm indeed privileged to be here this morning, just to mention. I'm greatly enlightened and deeply refreshed on the law of defamation, my lord. Thank you very much. The cost is, if I may ask,
20,000 is a full trial
20,000.
cost.
20.
Yeah.
Thank
You
you.
cannot get more from this court.
Thank you very much.
That's the limit. Anything to say, Lau?
I'll take it second one.
Yeah. Okay. So any other proceeding? Ada lagi?